Hey guys, welcome to my channel. So what I'm basically going to be doing in this course is I'm going to go over everything that we study in intellectual property rights in law school and in particular in Indian law schools. So although we'll be covering a lot of foreign cases, we'll also be looking at their connection to Indian law and how the Indian legal jurisprudence on those specific matters have been dealt with. So, I hope that you guys enjoy this. I hope that I am able to make it simple for you because I've always loved studying this subject in law school. And yeah, so I'm just going to be going through everything that we cover and covering all the cases alongside. Um, yeah, so that it'll be easier for you to study the course with this support. Now, what are intellectual property rights? First, I'm obviously going to give an introduction to what intellectual property rights are and what type of rights are covered under this area of law. So, firstly, we have, although I've written patents, I will be talking about copyright. So, in the beginning, or the way I'm going to structure this course is I'm going to start with copyrights, then move on to trademarks, and then move on to patents because that's how we were taught it. So, it just seems like the way to go. Copyright law. Now, copyright is an author's right. It's a legal term, of course, that's used to describe the rights of creators and the rights that these creators have over their works. Their works being either literary, artistic, etc. And I will be going into that later in this video. So, yes, that is what copyright is. Patent, on the other hand, patent is a license that confers on the right of title for a specific period of time, and of course it's the right on that excludes others from making something or using or selling an invention of yours. So it's related to ideas to an extent. Um, and lastly, we have, of course, trademarks. Trademarks refer to any symbol or word that are legally registered or established by use to represent any company or product. So as we have here, we have McDonald's sign. So this M, as well as the jingle that goes along with I'm loving it. So all of that is under trademark. That is the image and the sound. Um, when we look at copyrights, it's basically to do with something that is translated into a literary artistic work. And then again, as we have mentioned, patents, which refer to conferring a right of title for making a certain invention or to exclude others from doing that. So it's basically around an idea which you have to articulate in your when you register for a patent. So while I'll be going into all three of these in detail, I will be starting with copyright law, which is how I also studied it. So, copyright law. Now, how did copyright law originate? It originated from the Statute of Anne in 1709. Now, before the Statute of Anne, there was, of course, protection on works to an extent, but there was no protection of works given to an individual author. There was certain other acts that allowed publishers and printers to protect their works, but the Statute of Anne was actually the first copyright law that granted copyrights to individual authors rather than to publishers or printers. And the statute actually is a milestone in the history of copyright law because it recognized that these authors can be the primary beneficiaries of copyright law. And also, of course, it established that copyright should be for a period of time. That is, it should be for a duration, but you can't indefinitely have, total control and right over a specific work, right? It will reach the public domain and should enter the public domain at some point. So that was also established by the statute, and then of course, after this, a lot of other countries developed their own copyright laws. So now coming to the types of works that are protected under copyright law. So we have works that are literary works, which could be things like blogs, books, tweets also are literary works. Then we also have musical works, but musical works and sound recordings and all of these, they're sort of complicated to understand the difference, and Actually, in law schools, we generally do have full elective courses on musical copyright because it's a whole other domain. Um, but also, I will be going into that when I do that course. But yeah, as of now, to know simply is enough that the types of works include musical works and sound recordings, also dramatic works like plays, productions, choreographic works, which are like dance choreographies, um, pictorial and graphic sculptural works, all of these things. Uh, yeah. Then the next important point to remember about copyrights is copyright protects tangible mediums and not ideas and not facts. So by tangible mediums, what I mean is that when an idea is translated into a medium like a book or a movie, only then it is copyrightable, only then it is protectable, right, under copyright. Because until you translate that into a material form, you cannot say that just because I have an idea, someone steals it, I have the right to sue them because it's my idea. Once you materialize that idea, is that copyrightable and protectable by copyright. And also, of course, not facts means things that are facts cannot be something you can't claim to have created them, so nobody can have copyright over simple facts. And we'll be discussing that in the case of Feist publications versus rural telephone services. Um, then the next point that is important to remember is copyright must be by an author, right? So it has to be by the creator of something that who gets the copyright of that thing, right? And actually, there's an interesting case which is the monkey selfie copyright dispute, which was actually a case where in the US where there was a photographer David Slater, and he was a wildlife photographer, and one of the monkeys he was taking a photo of, he took his camera and took a selfie. So the question that came up in court was whether the monkey has the copyright to that photograph. So it was actually a full-fledged case, and you can Google it. It's quite interesting. There are a lot of videos about it. But while it was argued that he who originates does not specify who or what, so technically a monkey could be the owner of copyright, the court did eventually go with the fact that he's not a legal person, so it does not make sense to state that the monkey can be an author. So yeah, this was a very interesting case. Um, it also was argued, of course, by David Slater's counsel that it makes no sense to say that a monkey can be an owner of copyright, because it's equally absurd then to deny a monkey of a written notice for appearing in court. So you can't really say that, even though it may not be specified human being. But yeah, now it's very well known that the author must be a human being. Yeah, then the next and the last two important points that you should always keep in mind about copyright law are works made for hire. So, where does the copyright lie in works made for hire? So, if your boss tells you to create something, to make something, to write something, then are you the author or is the company the author? Now, it's clear that is when you are, and if you are clearly in the scope, doing something within the scope of employment, then you are not the author, then it is the company that is the author. But of course, if there's no clear, you know, definition, or there's no clear employer-employee relationship, then obviously the court has to look into things like whether you were doing this work during work hours, whether you created it on the computer of the employer, whether you were directed by your boss to do something like this, right? So all of these things will come into question. But as a rule, a work for hire that is done by the employee, that the employee is paid for during work hours, is something that the copyright in that will lie with the company and not with the person or the author who actually like created that work. um, yeah, and there will be many interesting cases about work for hire that we will be covering. So just remember this basic rule so that we can use it when we're studying the rest of the other cases. So yeah, and the last thing is, do you need registration? Now, registration for a copyright, it may seem essential because you're like, you have to register your copyright to have certain benefits to be able to go to court, but that's not entirely true. You still do have that copyright the moment you create a work. You don't need registration, but there are obviously certain benefits that you get from registration, and those are also stated in the Copyright Act. And yeah, we will be also studying that during the rest of this course at some point. So yeah, this is the basic introduction to copyright law and IPR. In the next video, I will be discussing the cases in the first module, which discusses the sweat of the brow test. That is a very important test in copyright law. You'll be hearing it a lot. And yeah, so we will be going over 5 to 6 cases in the next video, after which we'll move on to the next module. So see you guys there. Thank you for watching.